Good morning, everybody. It's Mike Kennedy, Vermont Bar Council. Early morning on Tuesday, April 21st. Welcome to the garage, or maybe back to the garage. If you've been here before, you know been doing some presentations from my garage during the pandemic. On that, I hope everybody's staying healthy and safe, being good to each other, being good to yourselves. If you're new, these officially are known as the Garage Bar Studios. The setting's a little more relaxed than a normal CLE, as you can tell, both in the, my attire and the actual setting itself. But the substance is going to be all there. Speaking of the attire, yesterday would have been the Boston Marathon. This year, obviously it wasn't run, but I'm wearing my Boston Marathon jacket, sort of in solidarity. From the year 2013, I ran it that year. That's the year the bombs went off. So maybe we shouldn't be talking about things like pandemics and bombs. Maybe we should get to the presentation. Today I want to share with you an overview of Vermont's Professional Responsibility Program. I think it's important for lawyers to understand the basics of how it works for a couple different reasons. Mainly, or not the least of which, is the fact that your attorney licensing fees pay for us to do what we do. So here's what we do. In Vermont, the Supreme Court has the constitutional authority to run a discipline system. So if you didn't know, and usually I have to go over this at CLEs for like civics groups, rotaries and stuff. I don't work for the Attorney General or the Bar Association or the Secretary of State's Office of Professional Regulation. I'm an employee of the judiciary because that's where the Constitution vests control of the discipline of attorneys with the court. The court's done two things. It has adopted permanent rules that govern and establish the Professional Responsibility Program, and it's adopted rules of professional conduct. Those permanent rules, those appear in Administrative Order 9. We call it AO9 in the lingo. They set up the program and the rules that it has to abide by to exist. The rules of professional conduct are, of course, the legal ethics rules that lawyers have to comply with to keep their licenses. Both AO9 and the rules of professional conduct were adopted in 1999. Each has been amended many times since. For those of you old enough to remember, the program replaced the old Professional Conduct Board, and the rules of professional conduct replaced the Code of Professional Responsibility that had, the old canons and the ethical considerations, things like that. So Administrative Order 9 creates each of these sort of entities, positions. There's the board itself. There are Bar and Disciplinary Counsel, the two full-time employees of the program. Then there are assistance panels and hearing panels, which are our volunteers and effectively our trial courts. And we'll talk about them in a bit. First, the board. The board, by rule, has 7 people. 3 must be lawyers, 3 must not be lawyers, 1 must be a judge. The board meets 3 or 4 or 5 times a year. It's not adjudicatory. The board is responsible for policy and administration of the program, including supervision of bar and disciplinary counsel. The board, later on I'm going to talk about me screening complaints and responding to inquiries, and Sarah Katz, who's disciplinary counsel, conducting investigations and prosecutions. The board does not direct those. The board does not get involved in telling us what to do in any particular matter on a day-to-day basis. The board's really policy and supervision. It does periodically review the rules of professional conduct and the provisions of Administrative Order 9 to suggest changes to the court. But again, the board has no adjudicatory role. First full-time position is bar counsel. Right now that's me. I've been bar counsel since 2012. 4 core aspects to my job. The first is to respond to inquiries related to legal ethics and professional responsibility. The second is CLE, education and outreach, again on professional responsibility and legal ethics. Skipping number 3 to go to number 4. Bar counsel screens all disciplinary complaints that are filed against attorneys, and I'm going to talk about the screening process. And then bar counsel also administers, number 3 there, the non-disciplinary dispute resolution program, which is a program to which I can refer a complaint after it's been filed and screened, or that disciplinary counsel, Sarah Katz, can refer a complaint after it's been filed or screened. And that's really an area, as you'll hear, where the complaints are too serious to dismiss out of hand and maintain any credibility, but not serious enough to warrant a prosecution against the lawyer's license. Inquiries of bar counsel. So many of you have made inquiries. People call me all the time, or email or text, doesn't matter. And my job is to provide guidance, referrals to the appropriate resources for the lawyer to consider. And I say that it's guidance because there's been a couple instances lately that people have been confused. I am not the caller or inquirer's lawyer. I do not form an attorney-client relationship with the inquirer. I don't give legal advice, nor do I issue formal advisory ethics opinions. I give guidance. I share my thoughts. Basically what I do is somebody calls and says, Mike, I've got this going on in my practice. I want to make sure I comply with the rules, avoid a complaint being filed against me. What do you think? And I'll point the lawyer to the rules, to the comments in the rules that are helpful, to any decisions that our hearing panels or the Supreme Court have issued, to any advisory ethics opinions from the VBA, the ABA, or other states. And then I leave it up to the lawyer to make his or her own decision. I can't tell the lawyer, you have to do this or else, or you better not do this or else. Can't do that. I just give guidance. I do share my thoughts on types of conduct or omissions that are more likely to lead to complaints being filed than others, but that's it. Lawyers are free to do of their own choosing, and in fact, that's what the system contemplates that they do, however, with guidance. Inquiries are completely confidential. I cannot share the substance of or even the fact of an inquiry with anybody, including disciplinary counsel. That's per board policy. Also, in 2016, the Supreme Court amended Rule 8.3 of the Rules of Professional Conduct to exempt bar counsel from the mandatory reporting rule. So I can learn of misconduct in the course of an inquiry, and per board policy, I'm prohibited from sharing that misconduct with disciplinary counsel. Per court rule, I'm exempt from having to report it. One thing I do want to add, I never opine or give guidance on, specific guidance on another attorney, the non-inquirer's conduct. So for instance, somebody calls and says, Mike, I think the other attorney on the other side has a conflict of interest. So I don't know, maybe that attorney does, maybe the attorney doesn't. If you are contemplating filing a motion to disqualify, here are some cases where the courts and our hearing panels have addressed the rule on disqualification. I will never ever say, yes, that attorney has a conflict, because I don't know. For all we know, the attorney has a waiver. There are two sides to every story. So if you ever have somebody contact you and say, Mike Kennedy said that you violated the rules, that's not accurate. Okay. Bar counsel also screens complaints. The screening rule is in Administrative Order 9, it's Rule 10, and the rule authorizes the screener, bar counsel, to conduct a limited investigation to figure out what's going on and then decide, 1, should the complaint be dismissed? 2, can it be resolved? Not quite dismissed, but not referred for investigation and prosecution? Or 3, does it appear that disciplinary sanctions might be warranted and therefore it's referred to disciplinary counsel for an investigation? When a complaint arrives, the first 3 things that happen, my assistant assigns a docket number and acknowledges to the complainant that it's here, and explains the process in a letter. I send an email most of the time, sometimes a phone call, but usually an email to the respondent, the lawyer, that says a complaint's been filed against you. I have to screen it. Here's the screening rule. How do you want me to send the complaint to you? Please let me know. Email, regular mail, whatever. I never attach the complaint to the initial communication. And this might seem minute. Why is he talking about this? Here's why. There's a scam, relatively common, that targets lawyers. That is an email scam that says, a complaint has been filed against you with the state bar. Click here to read it. Includes a hyperlink that will then download malware onto your computer. We don't do that because of the scam. We do send emails that ask you to let us know how you'd like the complaint sent to you. The screening process is informal, usually at least a phone call with the lawyer and the complainant to sort of figure out exactly what the complainant's saying, what the complainant expects. Very rare that I require a written response from the lawyer, although sometimes it happens. Sometimes it's helpful to have that response in my file later on down the road. I'm going to talk about that in a minute. But it's usually just me talking to each, trying to get a sense of what happened. I do often review court records. Many complaints, of course, involve allegations related to a case that's either pending or recently closed, and I'll check the court's docket sheet to see what went on. That's the screening process. If I dismiss a complaint at screening, the complainant has 30 days to file an appeal with the chair of the PRB. That's why I mentioned a minute ago that sometimes I do ask for information from the lawyer, because then it's in the file to document my decision. On appeal, the chair can either uphold my decision, or order the complaint referred to disciplinary counsel for an investigation. I can also refer a complaint upon screening to non-disciplinary resolution, our assistance panels, which I think are the next slide or two. But basically, that's a place where I send complaints that, they're too serious to dismiss out of hand. I mentioned this a couple minutes ago, but they're not serious enough to warrant prosecution against the lawyer's license. And I can also refer complaints for investigation. Those get referred to disciplinary counsel. When I do that, the lawyer gets 21 days to respond. Sometimes it's shortened in extreme cases that might involve, it looks like maybe money's been taken or misappropriated, but generally 21 days. Then once I make a referral to disciplinary counsel, my involvement ends. So disciplinary counsel and I work in the same program, but we're in different aspects of that program. Really two separate and distinct offices, both within the world of professional responsibility and legal ethics, working under the supervision of the same board. But disciplinary counsel has no role in the screening process, doesn't even know a complaint's being screened, and I have no role in the investigative and prosecutorial process. That's disciplinary counsel's job. So we're separate offices. So here are the assistance panels. That's where those cases that are in between go. It's non-disciplinary resolution. The panels are made up of volunteers. I have a roster of about 30. Whenever I refer a matter to an assistance panel, I go through the roster and pick 3 people to serve on the panel. By rule, at least one of those people must be a non-lawyer, and at least one must be on the PRB. So the board doesn't have adjudicatory power, but whenever we do these sort of little mediations, these non-disciplinary resolutions, at least one board member has to be on the panel. The rule does not require the assistance panels to meet with the complainant and respondent, although it authorizes the panels to do so, and they often do. When it happens, it's very informal, essentially listening to the complainant's concerns, listening to the respondent's response, and then just trying to get everybody to come to some sort of resolution, to put it to bed, make the complainant understand that we listened, we heard you, and to make the respondent understand, hey, you got to be careful moving forward. This didn't get referred for investigation and prosecution, but it was significant enough to just not dismiss out of hand. The panels can impose conditions, for instance, go to a CLE, an apology letter, a trust account audit, things like that. That's not common, but it can happen, and conditions can only be imposed at the assistance panel level if the lawyer consents. Finally, assistance panels can take a look at a matter, hear the complainant, hear the lawyer, and decide, this is too serious for us to resolve in a non-disciplinary setting. This should be referred to disciplinary counsel. So disciplinary counsel. Disciplinary counsel's job is to investigate and litigate disciplinary complaints that are referred for investigation. Right now, she does not have a full-time investigator, and Sarah Katz is disciplinary counsel, The board has, however, authorized Sarah to contract with an investigator for certain cases. The investigative process then, well, how does she do it? By rule, the failure to cooperate with a disciplinary investigation is in of itself a disciplinary violation. I was the prosecutor from 2000 to 2012. And when I first started, I often had to prosecute lawyers for failing to cooperate with an investigation, specifically failing to send in a response to a complaint that was referred for investigation. Lawyers were sanctioned for that. Got to the point where one lawyer was suspended. It was a short suspension, it might have been 60 or 90 days. And by the time the lawyer actually filed a response, it became clear that the lawyer hadn't violated the rules as alleged in the complaint, but the lawyer still was suspended for failing to cooperate with the process. That was about 2004, maybe. Since then, we've not had to prosecute a lawyer. We've not had to chase down the answers, but it could happen. During the investigation of a complaint, disciplinary counsel can also request what's called an investigatory subpoena from a hearing panel that would require somebody to show up and give or present evidence or testimony under oath. Disciplinary counsel can't just say, hey, can I have one, and then get one. There are a series of criteria, a set of criteria that disciplinary counsel has to show is present in order for one of those to issue, but it is a tool at her disposal. Disciplinary counsel investigates and prosecutes matters other than are referred by a bar counsel by a complaint. For instance, in Vermont, banks, as a condition of being able to hold a trust account, an attorney trust account, must agree to notify disciplinary counsel whenever an instrument drawn on the trust account is presented against insufficient funds. So not just an overdraft, but presented against insufficient funds. We get about 25 to 30 of those per year. In the year 2000, we didn't even open these as docket numbers. So sort of behind the times we were back then. But we received about 65 or 70. We decided many years ago that notices of overdraft or insufficient funds notices are not going to be screened out by bar counsel. They will go directly to disciplinary counsel for review because client money is at issue and protecting client money. Disciplinary counsel also has the authority, even without an insufficient fund notice, to order a compliance audit, and she does that. We've done that probably, I think we started in 2006, do between 12 and 15 a year, where a CPA will show up and not unannounced, you get notice, and review the lawyer's trust accounting system to see if the system meets the minimum requirements of the rule. So there's a rule, Rule 1.15 capital A, that sets out what a lawyer's trust account system must include. We do compliance audits to make sure that the systems are up to snuff. Disciplinary counsel can open a complaint without receiving one. So for instance, learns of a potential violation, disciplinary counsel can investigate on her own. And there's a thing in our system called an interim suspension. I don't remember the exact language of the rule, but essentially when a complaint comes in, bar counsel refers it to disciplinary counsel, and disciplinary counsel takes a look, and the evidence is pretty clear that there's been a violation, and not only that the lawyer poses a substantial threat to the public. Disciplinary counsel can, at that point, that initial point, go to the Supreme Court and request an immediate interim suspension. And I guess the analogy would be that it's like being held without bail. So normally, in 99% of the cases, lawyer continues to practice while a complaint is being investigated. There are some who've probably had, 10 in the last 10 to 15 years where a lawyer is suspended pending the investigation. Usually that's if the lawyer has committed a crime. Once disciplinary counsel's investigation is complete, disciplinary counsel can dismiss the complaint. When disciplinary counsel dismisses following an investigation, there is no appeal. Disciplinary counsel can also look at a complaint, investigate it, and decide, you know what, this should go to an assistance panel for non-disciplinary resolution. So the assistance panels can get complaints from bar counsel at screening or from disciplinary counsel after an investigation. And finally, disciplinary counsel, upon concluding the investigation, can commence formal disciplinary or disability proceedings. And today I'm going to focus on disciplinary proceedings. So disciplinary counsel can't just file charges against the lawyer. First, disciplinary counsel has to submit what's called a request for review for probable cause to one of our hearing panels, which I'm going to describe in a bit. A request for review for probable cause, I did probably 100 of them. It's an affidavit. It must include an affidavit from disciplinary counsel that says, this is what I did, this is what I discovered. Then it includes a memorandum of law that argues, based on what I did and discovered, I think there's probable cause for you to conclude that the lawyer violated whatever rule. It's ex parte, the lawyer's not involved, although I think Sarah does, and I did, would often include the respondent's response with our affidavit of this is what I did. So the panel has that and understands. If the panel finds that there is probable cause, disciplinary counsel must proceed with charges. If the panel says no, there's no probable cause, the board many years ago adopted a policy that disciplinary counsel just can't go back and ask again or ask for a different panel to review it. So more often than not, what happens is the complaint gets dismissed. However, the policy does allow disciplinary counsel to submit a new request if disciplinary counsel discovers new evidence. Let's assume probable cause is found. Disciplinary counsel has two options to commence formal proceedings. The first is by filing a petition of misconduct. That's our version of a charging document, like a complaint in a civil action or an information or indictment in a criminal action. When that happens, the lawyer has 20 days to file an answer, and the lawyer has to admit or deny each allegation in the petition. And then the parties have 60 days to engage in discovery. Discovery is limited to depositions and reasonable requests for production. Another way disciplinary counsel can commence a proceeding is by filing with the respondent stipulated facts. So disciplinary counsel and the lawyer agree, here are the facts. They stipulate them to them and submit them to a hearing panel. Then they recommend conclusions of law based on those facts. For instance, based on the stipulated facts, we recommend that you conclude that the lawyer violated the rule on client confidences. And we also recommend that as a result, you impose this sanction. They don't have to join to recommend the same conclusions or sanction. They can recommend vastly different conclusions and sanctions. So for instance, stipulated facts, where disciplinary counsel recommends that the panel conclude the lawyer violated the rule on client confidences and should be suspended. But the lawyer argues, no, I think that based on the stipulated facts, there's no basis to conclude that I violated the rule and therefore I shouldn't be sanctioned. The hearing panels who consider these, our version of the trial courts, they are different people than serve on the assistance panels. The hearing panels each have 3 members. By rule, 2 must be lawyers, 1 must not be a lawyer. No PRB member can serve on a hearing panel. And unlike the assistance panel process where I choose from that roster, the hearing panels are standing panels. We have either 9 or 10 throughout the state. We've also contracted with a lawyer who serves as counsel to the hearing panels, does legal research, provides legal support at the hearings, does a great job for them. That's Mark DiStefano. At these hearings and in the process leading up to the hearing, the rules of civil procedure apply, the rules of evidence apply. Hearings are public. A matter becomes public in our system once disciplinary counsel commences formal proceedings. Disciplinary counsel has the burden of proof, and the standard of proof is by clear and convincing evidence. In a hearing, whether it's begun by stipulation or petition, the hearing panel must issue a written decision. The written decision must include its findings of fact, its conclusions of law, and if it concludes that there was a violation of a rule, a sanction. When it comes to sanctions, the Supreme Court, has been very clear for as long as I remember. And I started in '98. that the purpose of disciplinary sanctions is not to punish the lawyer. Purpose is threefold. One, to protect the public. Two, to deter misconduct by other lawyers. And three, to promote and maintain confidence in the bar's ability to self-regulate. These are the sanctions that the panels have available to them. There are 4. An admonition is private, does not identify the lawyer or otherwise impact the lawyer's ability to continue to practice. A reprimand is public, but does not impact the lawyer's ability to continue practice. So for instance, if I did something wrong and was reprimanded, it would say my name, but I can keep on practicing. If I was admonished, it wouldn't say my name, but again, I could keep on practicing. A suspension identifies the lawyer, can't practice. Disbarment, same thing, identifies the lawyer, can't practice. How do they choose? Well, in Vermont, the court has said that we will follow, for guidance, the ABA's standards for imposing lawyer sanctions. And the ABA standards look at 3 factors: the duty that the lawyer violated, the lawyer's mental state, whether it was intentional or negligent, and the injury, if any, to the client, to an opposing party, to the court, to the legal profession. More specifically, here's how that works. So I took the ABA standards that apply in situations where a lawyer fails to preserve and protect client property. Per those ABA standards, this is what the panel would be looking at for a menu. Disbarment would be appropriate if the lawyer knowingly converted client property and caused injury or potential injury. Suspension would be appropriate if the lawyer knew or should have known that the lawyer was dealing improperly with client property and caused injury or potential injury. Reprimand is appropriate when the lawyer was negligent in dealing with client property and caused injury or potential injury. And an admonition when a lawyer was negligent and caused little or no actual harm. So if you look again at the 4, talk about the lawyer knowing, should have known, negligent, or negligent with no injury, and then so that's what the panels look at when they impose a sanction. Once they go through that, they get to what's called a presumptive sanction. So let's say they decide in any particular case the presumptive sanction is a public reprimand. They apply then, based on the evidence presented to them, any aggravating and mitigating factors. So for instance, an aggravating factor under the ABA standards is a prior record of discipline for similar misconduct. If this is the 4th time the lawyer has done this, that might aggravate the sanction from public reprimand to suspension. A mitigating factor would be the flip side of that: no previous record of discipline, good reputation, cooperated with the process, no selfish motive in the misconduct. And so that's how that works. Once those are applied, they get to a sanction. They do an analysis of prior case law just to make sure that this type of conduct and our response to our response is similar to what the court has imposed in prior cases, so we're not sort of way out of bounds here by choosing this sanction. Suspension in Vermont, there are 2 types of suspension. After a disciplinary case, the short suspension, short in air quotes, is 6 months, and when it ends by a rule, the lawyer can just start practicing again. If a lawyer is suspended for 6 months or longer, the lawyer must petition for reinstatement to the bar, and I'm going to talk about that in a minute. In Vermont, disbarment is not permanent. Disbarment is 5 years, essentially a 5-year suspension, after which the lawyer may petition for reinstatement. A couple little notes about sanctions. Disciplinary probation can be attached to any sanction. For instance, that might include, going to CLEs, series of trust account audits for the next 18 months. If a sanction issues, a hearing panel can also order the lawyer to return any fees or funds to the client. Many states, sanction orders include an assessment for the cost of proceedings. Our rules do not allow that, except in reinstatement cases, which I'm going to mention in a minute, and a case alleging a violation of a disciplinary probation. And we rarely seek disciplinary probation. I shouldn't say it. I don't know what Sarah's position on that is. I didn't. because it's hard to supervise. We don't have the resources for that. Here's the appeal process. Once the hearing panel issues a decision, both disciplinary counsel and the lawyer have 30 days to appeal. If no appeal is taken, the court can still order review on its own motion. If an appeal is taken or if the court orders review, the appellate process is just like the normal appellate process. If there's no appeal and no review within the 30 days, the hearing panel decision becomes final and has the full force and effect by rule of an order of the Vermont Supreme Court. So there's no intermediate level appeal. It goes straight from the hearing panels to the court. Reinstatement is the flip side of a disciplinary prosecution. Essentially, a lawyer files a petition for reinstatement and must show that the lawyer has complied with the criteria in the reinstatement rule in order to be allowed to come back to practice. Our hearing panels hear those. The lawyer bears the burden of proof by clear and convincing evidence. Disciplinary counsel can oppose, join to recommend reinstatement, or take no position. There's the standard, I just mentioned it, don't need to bore you with that. Essentially, the lawyer bears the burden of proving, won't be a danger to come back. So that's us, that's what we do. Since I started as bar counsel in 2012, I've tried to focus us on proactive regulation. Last year, the ABA adopted a resolution encouraging jurisdictions to become more proactive with their attorney regulation system. Here's the resolution, but essentially proactive regulation is in paragraph A. You put a focus on assisting lawyers to develop their practices and so as to include ethical infrastructures that prevent them from violating the rules. So that's why we do the inquiries. That's why we do all the CLEs, raising awareness, trying to create what I call a culture of compliance. And then a benefit of that type of proactive encouragement to lawyers, instead of just responding to them after they violate the rules, is reducing complaints, making lawyers more competent, very first rule, and cost effective in their provision of services. And we also, as part of this, do encourage professionalism and civility, because that does help the image of the practice, and it does tend to reduce a little bit complaints that are filed. I think it's working. Okay, sorry, I missed a slide there. So basically, with the proactive regulation, we work to prevent problems. My analogy is we work to prevent forest fires instead of, like in the old days when I was the prosecutor, just waiting for the fire to begin and then putting it out. Helping to prevent fires helps lawyers, and that's what we should be doing with the fee we charge you. And it also protects the public. The public is not necessarily protected as well when all we do is respond to misconduct instead of helping lawyers to not commit misconduct. I think it's working, what we do. Throughout the first decade of the 2000s, which is not on this chart, we averaged about 275 complaints a year. This chart is the number of complaints we've received each year since 2012. On the left is 264, then it actually went up the first year to 286. Since then, it's dropped significantly. Last fiscal year, we only opened 130. This year, our fiscal year ends at the end of June. We're on pace to open about the same, 130. So we've halved complaints. Over the same period of time, inquiries have risen from 600 the first year. We switched to full-time bar counsel. To last year, I did just over 1,200, and I'm on pace to do the same again this year. So I think it's working. That's us. Last slide, I like to do a little pop culture icon of every segment that I do here from the garage. So given that I'm wearing my Boston Marathon jacket and that I'm talking about professional ethics, our pop culture icon of the segment is Rosie Ruiz. Some of you may remember her. In 1980, she allegedly won the Boston Marathon. That's her on the left, crossing the finish line. That's her on the right with her laurels. Of course, she didn't run the full Boston Marathon. She ran about a mile and took the subway the rest of the way, hopped out and ran the last little bit. So that's not ethical, you marathon runners. Anyway, thank you all for listening. That's us. If you have any questions about what we do or how we do it, let me know. And otherwise, have a great day. Take care.